Marital property is ordinarily divided equally between the divorcing spouses, and each spouse is ordinarily awarded separate property, which may include premarital assets, inheritances, or similar assets. When dividing property in a divorce, the court first categorizes the parties' property as part of the marital estate or as the separate property of one or the other. Then, the court should presume that each party is entitled to all of that party's separate property and one half of the marital property, regardless of which spouse's name appears on the title to the marital property. The presumption is that the marital property will be divided equally, while separate property will not be divided at all. Married persons have a right to separately own and enjoy property, and that right does not dissipate upon divorce. Thus, equity generally requires that each party retain the separate property he or she brought into the marriage, including any appreciation thereon. But separate property is not totally beyond a court's reach. Before carving property out of the marital estate, a trial court must consider whether circumstances warrant an equitable override of the separate property retention rule. 3 circumstances have been identified under Utah law as supporting an award of separate property at the time of divorce. These exceptions are when separate property has been commingled, when the other spouse has augmented, maintained, or protected the separate property, and in extraordinary situations when equity so demands. It is critical that you tell your attorney all you know about all the property you or your spouse acquired separately before and during the marriage, and about the property you and your spouse acquired together before and during the marriage. The more your attorney knows, the more your attorney can protect your interests. Failure to fully disclose all property may subject the non-disclosing party to an award of non-disclosed assets to the other party, attorney's fees, or other sanctions deemed appropriate by the court. If you and your spouse can agree on how your property will be divided, and if your agreement is reasonable, it will likely be approved by the court. If you cannot agree, the court will divide the property for you. While attempting to make an equal or equitable division, the court may consider some or all of the following factors: duration of the marriage and who was at fault in the divorce, if anyone was, tax consequences of the division of the property, the type of property, each spouse's level of contribution to maintaining or improving the value of an asset, whether a spouse diminished the value or wasted the asset, the value of the estate to be divided, the financial condition of the parties, the ability of each spouse to earn money, how the property was acquired, the parties' respective health and ages, and all other pertinent facts and circumstances.